name is Mike Larsen, and I'm a faculty member in the Criminology Department, Faculty of Arts at Kwantlen Polytechnic University here on the unceded territories of the Coast Salish peoples. And I'm really pleased to be able to join you today to talk about freedom of information. I've been involved with access to information and freedom of information work for a long time now. Initially as a researcher, a lot of the work that I do as an academic and as someone who does research for public policy issues requires me to get access to information that public bodies have but don't publish, don't proactively make available to the public. This kind of stuff is really essential for people who are conducting research on issues of public institutions or public policy, but also for people who are looking to participate in a democratic process, to advocate for issues of importance, or to make informed choices as citizens. I initially started doing this work back in the early 2000s when the subjects that I was researching involved topics that simply weren't part of the public domain, involved information that wasn't really readily available. Naively, I started asking for this information directly. Could you please send me this? Could I have this? And that wasn't really successful. And what I really stumbled into, without much in the way of background or training, was the idea that in order to get access to some of these records and to exercise what I came to understand as a right to know, I needed to make use of freedom of information and access to information laws. And so today, what I would like to do is kind of walk you through the 101 of how you can go about exercising your right to know using FOI laws to get access to information held by public bodies. This is meant to be an introduction. You don't have to have any kind of background in access to information or FOI in order to make use of this. And I hope that you'll find this something that will help you in terms of being able to get access to the records that you need to do what you need to do.
Let's take a look at what this video is going to cover. We're going to begin with the basics. What are freedom of information and access to information laws? What are some of their common features? How do the provincial and federal laws in Canada differ, and how are they similar? After that, we're going to move on and talk a little bit about the preparations you can make before you file a request. And we're going to emphasize the processes you can use to access previously released records from previous FOI files. Then we're going to move into the tips and strategies you can use to plan an effective FOI request, an original request that you'll file on your own. After that, we'll take a look at what happens after you file a request, some of the questions that can arise, some of the challenges with the process, and how you can address some of these. And we'll close with some tips about effective use of FOI law.
Let's start by thinking a little bit about some of the common features of transparency laws. Now, like any other area of law, transparency laws can be complicated. They can be dense. There's a lot of decisions made. There's a lot of rulings from commissioners' offices, different interpretations of some of the different sections of transparency laws. But to be honest, there are a couple of really important key features that will allow us to get started with exercising our right to know and making use of FOI mechanisms. A few specific ones are worth highlighting.
At the outset, we should note that Canada doesn't have one freedom of information law. In fact, there is a Federal Access to Information Act that governs the right of access to all records held by public institutions at the federal level, the Canadian federal government. And that's usable across Canada, regardless of where you are, including if you happen to be filing requests for, let's say, federal institutions that operate provincially, for example, the RCMP. You also have provincial freedom of information and protection of privacy laws, which you'll find differ from province to province and across the territories as well. These only deal with public records that are held by provincial government institutions, but also by public bodies within the province. So, for example, in British Columbia, under the Freedom of Information and Protection of Privacy Act, you are able to file FOI requests for access to records held by provincial government ministries and the Premier's office, but also the same law is used to file for requests with municipalities, with provincial and municipal police organizations, and with other sub-provincial public bodies. Now, in some jurisdictions across Canada, you'll also have municipal Freedom of Information and Protection of Privacy Acts. For example, in Ontario, you have the MFIPA, which deals specifically with municipalities. And there are other access laws too. Some First Nations in Canada have their own Freedom of Information and Protection of Privacy Acts. For example, the Tsawwassen First Nation in British Columbia. But the primary distinction that you'll need to bear in mind is this one between the federal and provincial access regimes, because it will tell you which law you need to use and which mechanisms you need to use to file the request that you're looking for. So the starting point is to figure out, well, which type of public body, federal, provincial, or beyond that, am I interested in filing an FOI request with? At the federal and provincial level, access to information and freedom of information laws have a variety of features that they share in common. One of them is that they recognize and enshrine in law a public right of access to records that are held by public institutions. This is very important. The principle is that these public records belong to the public, and they should be accessible. In fact, accessible subject only to limited exceptions. This is important because it facilitates democracy itself, as has been recognized by the Supreme Court of Canada. But the other part of these laws is about those exceptions. FOI and transparency laws are also laws of secrecy. They embed directly in the law itself a variety of reasons or clauses that can be used by public bodies to withhold information from public access. Some of these seem fairly straightforward and important. For example, you don't have a right to file an FOI request for my personal information held by a public institution. This is a very important principle in terms of privacy protection. But others can be quite controversial. They can actually constitute mechanisms that governments can use to conceal information that really ought to be in the public interest. And so there is an ongoing struggle between transparency advocates and public institutions to reform laws in a way that facilitates a meaningful and timely public right of access. It's always worth taking a look at the FOI law that you plan to use to see how it works, but also the variety of clauses that can be used to restrict access to information. It's also worth bearing in mind that all transparency laws involve a three-part process, or rather a relationship between three different parties. On the one hand, there's you, that's the requester, the person filing the FOI request, composing it, deciding what to look for in the first place, and responding to any questions that arise while the request is in process. And the person receiving your request, or the office receiving the request, we'll call the Access to Information or FOI analyst. This is a person who is responsible for ensuring compliance with the transparency law in question, so provincially or federally. The analyst processes the request, but they actually are not the office that holds the records that you're seeking. That's what's called the Office of Primary Interest. This is whatever entity within a public institution actually maintains, keeps, has control of the records that you are actually after. The analyst acts as a middle person. They task the Office of Primary Interest with the request that you filed. If there are questions arising from the Office of Primary Interest, the analyst corresponds with you. In practical terms, this means that there is a cutout, which can be beneficial. It means that the Office of Primary Interest does not know who you as a requester are, unless, of course, you're filing for your own personal information, which you have a right to do. So there is a degree of privacy protection embedded in this for the requester. But it also means, and this is crucially important, that there is sometimes a game of translation or telephone that takes place between the requester, the analyst, and the Office of Primary Interest. In some cases, both the requester and the Office of Primary Interest are really familiar with the subject matter of the request, with whatever aspect of government work is the focus of the request. But the analyst may not be. The analyst is an expert in the application of transparency law. And so that's important to bear in mind when you're trying to explain what you're looking for or responding to questions, that you may actually have more of a background with the specific material of interest than the analyst themselves. And having a bit of patience with that process and trying to communicate clearly can get you access to the records you're looking for with less difficulty. There's lots more that we could say about access regimes and laws in Canada, but this is enough to get us started with thinking about how to conduct preliminary research for an FOI request, and to prepare and file a request of our own.
Before we get into how to file an original FOI request, let's talk for a few minutes about how you can get access to the records released in response to previous FOI requests or access to information requests at the federal level. Not every public body that's subject to transparency law in Canada proactively publishes the results of FOI requests, but some of them do, and these can be an incredibly useful resource for you. They may satisfy the information you're looking for in the first place, but they're also a foundational starting point for understanding how effective requests are composed and the kinds of information that are available to you. Let's take a look at this.
In BC, general records requests that focus on provincial government ministries or the Premier's office are published once they have been released, after they've been released to the original requester, online via the BC Open Government website. And this is a fantastic resource for you if you're looking to understand what's available and how requests are composed. You can visit this site and browse to locate particular types of issues or records pertaining to types of issues. You can look at the full release packages that accompany FOI requests, and also at the letters that are sent by the ministry in response to FOI requests that show you a little bit about what has been withheld, any kinds of issues associated with the request, and all of this is useful for learning. I often think of this as an important aspect of preliminary research before you start filing a new FOI request. It's really worthwhile to look at what has come before and then to build on that. There are a few things worth bearing in mind as you do this, though. And one is that the search function is limited to the wording used in the composition of the request, in other words, in the request itself, as opposed to a full search of the contents of the records that have been released. So bear that in mind. Sometimes a search won't get you anything or everything that's applicable. You may need to go and browse by ministry, browse by the public body itself to locate what you're looking for, the limitations of search engines. Another point to bear in mind is that BC's Freedom of Information and Protection of Privacy Act, like other provincial acts across Canada, doesn't just apply to provincial ministries or the Premier's office. It applies to public bodies throughout the province, including universities, municipalities, police organizations, and you won't find FOI release packages from these types of organizations or public bodies via the BC Open Government website. It's a one-stop shop for the ministries and Premier's office requests, but otherwise you're going to have to actually go to the website typically of the public body in question and see if you can find whether they have posted their own previously released FOI requests. Some institutions do. It's a best practice and one that I think certainly requires a lot of support and endorsement from the public. It allows people to access the records that others have put the work in to obtain in the first place and made public. As I said, some public bodies will do this, some won't. Actually, in some instances, it's quite difficult to find out where on the website you'll actually find a link for transparency or FOI in the first place. But search around, and if you are unlucky with this, contact the public body in question, and you can ask them for a list of FOI requests, including the request wording, the request name itself, so the file number, and any other kind of pertinent metadata about the request. You can ask for that and then browse through it and ask for the release packages of those previously released requests. Since they've already been processed, this should not be a challenging thing for public bodies to respond to. Again, there is a bit of sleuthing involved to locate some of this information when it's not archived at a ministry level. You can also access the release packages of previously processed access to information requests at the federal level in Canada. And for this, you want to go to the Canada Open Government website. All of the federal public bodies and institutions that are subject to the Access to Information Act are listed here by organization, and you also have a search function that will allow you to look for particular records of interest. So you can browse for the records released by particular institutions, or use a keyword search, again with the same limitations on those searches that they only correspond to the wording of requests themselves. Now, with the federal government, one of the benefits is that all of the public bodies subject to the Act are searchable here. One of the drawbacks is that the full release packages are not available online as they are in BC at the provincial level, but you can access them. What you have to do is submit an informal request to receive a copy of the previously released records, which you can do simply by clicking on the request of interest and filling out some information. And many public institutions will send this information to you electronically now. Some are still a bit outdated and will still want to send it by post via CD-ROM, which can take a little while, but there is no cost associated with doing this. So as a first step in research that involves any kind of public institution, if you're looking to get access to these kinds of records, I recommend taking a look at what's already been released and selecting from that menu of release packages. It may take a bit of turnaround time for you to get them, but again, a fantastic starting point, not only because the information itself may be of interest, but crucially because it reveals the kinds of records that are kept by public institutions. And this works at both the provincial and federal level. You can use the results of previously processed FOI and access requests to learn about the information holdings of public institutions, and so to better target your own original access to information or FOI request.
Assume that you can't locate the information that you need via some previously published website or other resource, and the results of previous FOI requests don't quite cover it. So you need to file an original FOI or access to information request. A lot of what I'd like to talk about today deals with how to compose this effectively and then how to deal with your request as it's in process. The composition of a request, the actual decision of what to include, the kinds of information you're looking for, how to phrase things, is really important because ultimately it kind of sets the ball rolling on the entire process. Phrasing of a request that is vague or overly complicated, requests for all information available as opposed to specific kinds of records that might be of particular interest, these things can actually create some challenges when it comes to the processing of your request and can give rise to things like fees and extensive delays on top of the delays that are kind of endemic to the FOI system itself. So let's talk about how to effectively compose an original Freedom of Information request.
When planning an FOI request, it's helpful to consider a couple of things. First off, you want to consider the types of records that exist and that are of interest to you. FOI law doesn't really target information so much as it targets records. It gives you a right of access to particular records held by public bodies. And using this law to its fullest potential, well, that really requires you to have a bit of an understanding of the kinds of records that exist and are of interest. So that's one of the things you want to consider. It's also worthwhile to consider whether any particular exceptions or exemptions might apply to the kinds of information and records that you are interested in. And for this, you'll want to consult the legislation itself, the Freedom of Information and Protection of Privacy Act or the Access to Information Act, both of which contain information about types of exceptions. If there are exceptions, that doesn't mean that you should withhold the request and not file, but it should mean that you should be prepared for some challenges when it comes to actually getting access to some of the information you're interested in. Now, conceptually, I think we can helpfully break down the idea of public records into three buckets or three types or categories of records. The first is what government knows. That would be statistical reports, data collected and compiled about trends, polling results, issue reports, sometimes briefing notes. These records are comparatively easy to access via FOI. So this is information about what government knows. The second category, we could say, are records that pertain to what government is doing. So this would be internal correspondence between public employees, evaluations of programs, some budget documents, other financial materials, communications documents, so Q's and A's and planned news releases, work plans, and certain training materials will fall into this category. These records are often accessible, though some exceptions may start to apply. And finally, and this is honestly why a lot of people are interested in using FOI in the first place, we would have records that cover why government acts the way it does, so rationales for decisions made, discussions about possible options or alternative courses of actions, analysis and recommendations documents, correspondence between cabinet members, information subject to solicitor-client privilege like advice from counsel, advice to decision makers. These are often the most difficult documents to obtain via FOI, as there are several exemptions in law that either allow or require public bodies to withhold them. And just to give you an overview, in British Columbia, the exceptions that apply under Division 2 of the Fipa would include things like cabinet and local body confidences. This is cabinet confidences, information that is generally not accessible via FOI. Policy advice and recommendations. So this is not supposed to cover the information upon which decisions are made or advice is based, but advice itself, an analysis of options. This also is subject to exception. Legal advice, subject to solicitor-client privilege, exception. Disclosure of records which could be harmful to law enforcement or to intergovernmental relations or negotiations, to the financial or economic interests of a public body, to the conservation of heritage sites, to the interests of indigenous peoples, to individual or public safety. All of these types of records, or records that can be categorized thusly, are subject to exception from release. Additionally, information can be withheld if there is a concern that it would be published already within 60 days of the time of the request. Information can be withheld if disclosure would be harmful to the business interests of a third party, or to personal privacy, or information relating to abortion services, which is specifically carved out in this exception in BC. So putting all of this together, there's actually quite a wide range of clauses that can be used to withhold certain types of information. Again, not a reason not to file for records of interest, but something to bear in mind as you are targeting your request and selecting what kinds of records might be of interest to you. It can be helpful to think of the process of composing an FOI request as a process of funneling or narrowing down from the general to the specific. I developed this document years ago when teaching FOI workshops, and I still actually use it for some of my own requests. It helps me to focus on what I'm actually interested in. It's a 4-step process. To begin with, we can think about identifying a general issue, topic, or research problem that we're looking to explore with access to information or FOI. What's the big picture? What's the issue in question? From there, we want to narrow it down to some specific questions, so things that we know that we don't know, or things that we would like to know. The reason this is useful is sometimes specific questions can actually be separate requests. It can be helpful to file several FOI requests to get at an issue from different angles rather than trying to throw all of your efforts into a single comprehensive, multifaceted request. That's step 2. Step 3 then is for us to think about which government bodies or public institutions might have the information that could help us to explore our research questions. In some instances, this is obvious. You're looking for budget information about a particular university, or you're looking for correspondence in the Premier's office. Those kinds of things, straightforward. But it's often the case today that work conducted by government institutions is conducted in collaboration with other public bodies, sometimes actually straddling different jurisdictions. Collaboration, the sharing of resources, partnerships, both with public sector and private sector, are commonplace. So it's actually worthwhile to think a little bit about, well, which institutions may have records of interest, because an FOI request will ultimately focus on a specific public body. In some instances, you may need to file separate FOI requests with several different public bodies to really get a comprehensive understanding of a particular issue. And finally, and we could draw on what we talked about earlier in terms of the different buckets of records, you want to make a list of the types of records that might pertain to the topic that you're researching. What, in general, are the kinds of records that would contain the information that you are seeking? So filling this out actually is a great way to go from the general to the specific, and it gets us ready to compose the actual request. When it comes to drafting and phrasing a request, there are a few essential things to bear in mind. First, at this point, you will already have selected the target public body, the institution that you're interested in filing with. Second, you need to clearly describe the record types of interest, and you can use a bulleted list. You don't have to write this in a long-form format, so you could actually give a list of the kinds of specific types of records, sometimes even the titles that you're interested in. Enumerate them, make them very clear and specific. The third thing is to avoid vague phrasing. You want this to be targeted as much as possible. Sometimes you don't know how to target it because there's little information available. But vague phrasing might be things like saying, all records pertaining to this issue, including but not limited to, which casts as wide a net as is possible. And there may be some circumstances in which that's a useful thing to do, but generally it's going to make the request process a bit overbroad and probably give rise to delays and likely fees as well. So you want to avoid that kind of phrasing. You also want to try to use the terminology that's used by the public body in question. And this is another reason why it's helpful to review previous FOI requests before you compose your own. If a public institution is using specific terms or language, some elements of bureaucraties to talk about something, you want to use that, and one of the reasons is when that request is tasked to the Office of Primary Interest, they'll probably try and pull the records for you that are subject to your request using keyword searches, using searches for the specific terms that you're looking for. That's one of the strategies they would use to compile that. So the more you can use the actual language used by the public institution, the more likely you're going to be able to zero in on those kinds of records. Again, avoiding vague phrasing if possible. You also want to think about and to specify a date range for requests. Now, typically, the online filing forms for provincial and federal access requests will require you to put in a date range of interest. Sometimes this is very straightforward. You heard an announcement that was made, and it said that this initiative is starting. And so you can kind of work back from there and get the date range in question. Sometimes it's unclear, but thinking about a date range is particularly important. Another way that a request can sprawl or take a bit longer than you'd like it to is if the date range is overbroad and it takes a long time to compile the records of interest. These are the essential elements for composing an effective FOI request. There are also some as-needed elements that you should include when the need arises in the phrasing of your request. So the first I'll say here is to provide some contextualizing information. And again, this goes to the idea that the analyst receiving the request may not have as much of an understanding of the issues that you're interested in as perhaps you do or the Office of Primary Interest. So what you can do is before you request records, you can provide a statement. On this date, the minister rose in the legislature and spoke about this initiative, and maybe even include a URL if you'd like to. This puts it on record that yes, this information does exist, and this is when this was mentioned. It can help with the tasking or targeting of a request. You could also say that, for example, in a previously released FOI package, and you could insert the file number, these records were discussed but not released. I am looking for these particular records. So those kinds of statements that situate the request can again help with the tasking. And make it easier for the public body to find the records that you're specifically interested in. You could also, if you wish, indicate the desired record formats and versions. So sometimes there are multiple drafts of the record in question. Perhaps there's a final report or issue statement or briefing note, but there were previous iterations and drafts, and you may be interested in the marked up drafts, so all previous versions, and you could request that. In other instances, you may want only the final version of whatever was released, so you can specify that if you wish. The record format issue is particularly important. Generally speaking, FOI requests that are released by public bodies across Canada are released in PDF format, and they are essentially flattened image PDFs. So although you could read text on them, they're not actually text files. You can't search them, you can't copy-paste in them. They're not really designed to be manipulated. They're designed to be snapshots of the records in question. In some instances, this is useful. In some instances, this is frustrating, and in some instances, it can make the records themselves inaccessible to people who have visual impairments, for example. And so if you want your records to be in a format that you can manipulate, then you need to specify that. For example, for people who are looking for spreadsheets and databases, an Excel document, let's say, you want to specify that you'd like that in what's called a machine-readable format. or the specific file type. And this is something that's supposed to be taken seriously by the analyst who's receiving the request, because they have a duty to assist you in ensuring that you can exercise your right to know. So specifying the format type is particularly interesting and important to do as well. Finally, in some cases, you may wish to indicate the record types that are not of interest. If there's very little information available about something and you need to cast a pretty wide net to get something that's relevant to you, you may want to say that I'm looking for any kind of reports, any kind of briefing materials and media lines that have been prepared, perhaps any slide presentations or budget documents, but I don't want correspondence. Don't need to search emails for records of interest, right? And this helps to narrow the request down again. Again, this is not something that you need to do in every instance, but it can be helpful in some cases to say, I'd like a bunch of records, but I don't need to look for these ones here. The search can be narrower than that. Again, it's worth noting the value of consulting previously released request packages, particularly if they are asking for similar kinds of information to what you're looking for. As an educator, normally I'm the first person to say you need to avoid plagiarism. It's very important for academic integrity. But when it comes to FOI, if someone has already phrased a request in an effective manner, borrow that phrasing, steal that phrasing, adapt it to what you're looking for, and it's more likely to get you something that you're actually seeking in the first place, right? So copy existing requests, change a few things to get what you're interested in, and use that as a starting point. Increasingly, we're seeing public bodies move to online filing forms for FOI requests. These allow you to input the information you're looking for, select the institutions of interest from a drop-down menu, for example, as we have with Information Access Operations that covers FOIs for the ministries in BC. But some public bodies also have their own printable or fillable forms that they wish you to use for FOI. It's important to note that you're not required to use these forms. The request has to be in writing, but you could write it on whatever you want. You could append an extra page if you can't fit what you're looking for in the space provided there. It's up to you, so long as you provide the requisite information to file the request and for the public body to get in contact with you. Depending on the kind of records you're filing for example, if they contain any personal information about you or information about someone else that they've authorized you to obtain, you will have to actually provide some additional personal information to gain access to those records. But typically, it's just a mode of contact and the records that you are seeking that need to be specified. To submit an FOI request or an access to information request, you'll also need to pay the application fee. And these fees differ in amount and acceptable payment types across Canada. The ideal fee would be zero. It's important that public records are available to the public. Fees represent a barrier to access, in some instances an insurmountable barrier. In British Columbia in 2021, we went from having zero application fee for filing an FOI request to a $10 application fee for requests for general records from public bodies. And that does represent a significant barrier. It's another reason why it's very important to do some preliminary research in order to ensure that your request is as effective as possible before you go out of pocket to pay that $10 fee, which can be done online. In BC can also be done by a mailed check as well. Federally, the Access to Information Act has a $5 application fee embedded in it, and the federal government has recently instituted an online filing portal that allows people to pay via a credit card, including a prepaid card. Again, this represents a barrier to access, but it is a necessary evil, unfortunately, for those who are seeking to make use of the current system. Another reason, though, to support organizations like the BC Freedom of Information and Privacy Association, which advocates for reduced and indeed eliminated fees as a principle of access to information in a democratic society.
In some cases, submitting your FOI request, especially if it's effectively composed and clear, is almost the last thing that you have to do as a requester. The rest of the work is going to be done by the Access to Information or Freedom of Information Coordinator or office receiving the FOI request. And you will get your response within the statutory time frame and can deal with the records that are released through that process. But that's not always the case. when you hit send or drop a request in the mail, as the case may be, sometimes the process still actually requires a bit of your active engagement. And in particular, we can talk about some of the things that happen around questions about the wording of a request, questions for clarification, extensions, delays, these kinds of things that can arise while a request is in progress. And in fact, it's these areas quite often where we see some of the biggest challenges with the FOI system.
It's important to keep track of your FOI and access to information requests. I like to use a spreadsheet or some other kind of filing system to keep track of both the wording of a request and also any correspondence related to it. And in particular, it's important to take note of things like the date a request is received. This will be indicated in the initial correspondence that you receive from the office that has received the request. This is important because there are statutory limits on how long public bodies can take to respond to a request. In Canada, it's 30 days, but it depends on whether that's calendar days or business days, depending on which act we're using. So it's always important to take a look at the legislation as you file. But that 30-day deadline is very important because if it is missed, you need to be ready to follow up and ask what is going on. So keeping track of the entire process will help to keep your own work organized. Additionally important if you should find that your access to information rights have not been respected and you wish to request a review or file a complaint. Sometimes there can be considerable back and forth while the request is being processed. In fact, this is such an important part of the process that my colleague Kevin Walby and I years ago published a book with UBC Press called Brokering Access that was looking at this kind of back and forth negotiated aspect of FOI and how it impacts people's right to know. But generally speaking, for our purposes, we can think about three major types of correspondence that can arise while a request is in progress. First, there are requests for clarification. And these would be efforts by the analyst who's been tasked with responding to your request to reach out to you with questions about the phrasing of the request itself. In many instances, this could be looking for some more specificity in terms of records that you've requested. When you say all documents, about what kinds of documents in particular are of interest, those kinds of questions can help to focus and task the request effectively. You may also have an analyst reach out to you and ask if you would be interested in information related to your request that's already publicly available, perhaps that you might not be aware of. And in those instances, you can absolutely say yes, but that doesn't mean you have to abandon or suspend your request. If you still think that there's information that hasn't been released, of course you can proceed with that as well. Always important to be active in responding to these kinds of requests for clarification. You may also receive an extension notice, a formal notice from the public body in question that they will be taking longer than the typical statutory time limit to respond to your request. And this can be done in some instances at the discretion of the public body if it's an initial extension, and in some instances it requires notification of the commissioner that's responsible for overseeing the particular legislation in question. So it's not uncommon at all for public bodies in British Columbia, for example, to claim a 60-day extension or a 30-day extension on an initial access to information or FOI request. Ostensibly, this is due to the workload of the institution, the time it takes to compile the records that are responsive to a request, the number of requests that need to be processed in a limited time frame. But sometimes requests can be extended almost indefinitely into the multi-year range when there's additional research that needs to be taken or when the institution itself is extremely backlogged. And in many instances, these requests can enter what's called a deemed refusal status, which is a situation where the public body has not formally responded to a request, but they've run out of time for extensions or they haven't claimed another lawful extension. And this itself is reason for a formal request for review or complaint about the process. Sometimes extensions are subject to a degree of negotiation in the sense that you may wish to narrow a date range, let's say, to expedite the process with the request. And an important tip is if there is an extension that's been claimed on one of your FOI requests, you can ask, while the request is still in process, that the records that have been processed already are released to you, rather than waiting until the end of the entire process. And this can help you to get some information you need sooner rather than later. Generally speaking, it's my position that access delayed is access denied. One of the endemic problems with FOI systems in Canada and elsewhere in the world is that the delays in the processing of requests can mean that people don't get the records they're looking for in a timely enough fashion for them to make true use of them, which can be extremely frustrating, and again, it points to the importance of having focused and effectively composed requests. Many FOI regimes also allow for the assessment of fees for requests that are in process. Typically, this is meant to cover situations in which the time it takes for a public body to retrieve the records for a large and complex request would be unreasonable, and there is additional work that needs to be done in order to put people on task to locate what you're looking for. Fees are subject to complaint if the fee seems unreasonable, and in some jurisdictions you can also request a fee waiver. For example, in British Columbia, if there is a fee assessment, you can request that that fee be waived on the grounds of financial hardship. That is, you really can't afford to pay it, but you still wish to exercise your right to know, or on the grounds that the records that you are seeking are in the public interest and that there should not be a fee that serves as a barrier to accessing them. But fees can be one of the most contentious sticking points with requests that are in process. And in some instances, I've seen fees assessed that really aren't a reflection of the complexity of the request so much as the lack of effective and efficient information holdings by the public body. They have to do more work because they're disorganized. Not always the case, but sometimes. When there is a fee assessment, you'll typically receive a formal note or email indicating that there has been an assessment and that you are requested to put down a down payment for the request to continue being processed, typically 50% of the overall estimate of the fee, which is based on a calculation of how long it's going to take to process your request. You can pay this if you want to keep the request moving, but still challenge it. You can still say, I'm going to pay this so that we can keep going, but I'm going to request the fee be waived, or I'm going to complain about the fee, the amount or the nature of the fee, to the ombudsperson in question. And that doesn't actually prevent the request from moving forward while that's in process. So these are some of the most common aspects of correspondence that can arise while a request is in process. Several times during this video, I've made reference to the commissioners or the ombudsperson offices that are responsible for overseeing the FOI mechanisms in question. And it's worthwhile for us to speak at this point about who they are and what they do. There are provincial and territorial information and privacy commissioners. So, for example, here you see the website of the Office of the Information and Privacy Commissioner for British Columbia. Federally, we also have an Information Commissioner of Canada. And their responsibility is to oversee the administration of the Act and ensure that public bodies are complying with it by responding to requests for review, to complaints, investigating the processing of files where there have been requests for review or complaints issued, and making decisions about whether information has been unduly withheld, whether the process has been adhered to, whether exemptions have been applied appropriately, whether public bodies have followed through on their responsibilities under the Act. Now, you may wish to contact an information commissioner if you feel that your request hasn't been responded to appropriately. But it's also just useful to bookmark their website and to make use of it. Information commissioners' websites in Canada have started to become clearinghouses for information about the how-to of the access to information FOI processes. And the BC Info Commissioner is particularly useful because they have what's called a sectional index on their website. You can go to the OIPC website, take a look at the sectional index, and select the section of the Freedom of Information and Protection of Privacy Act that is of interest to you. So it could be a section that deals with fees, could be one that deals with exemptions, could be one that deals with the duty to assist. And you can take a look at the full text of rulings and decisions that have been made by the Commissioner in previous investigations into the application of this section. This is advantageous because it gives you an opportunity to understand what is the going rate or official interpretation of particular sections. What is an unreasonable delay, for example? What are the specific grounds upon which information can be deemed policy advice and therefore withheld? These are some of the nitty-gritty questions that won't come up in every request, but will come up if you are routinely filing FOIs. And this is one of the best resources that you can use to inform yourself about the process. We're coming to the end of this video, and I want to leave you with some tips based on things that I learned as I started filing FOI requests and learning about the process. A few final pointers. So the first one is to not rush request modification decisions. What I mean by this is if there is a request for clarification or perhaps suggestion, would you like to narrow the time range of your request or maybe exclude these kinds of records, it is important to get back to the public body promptly, but you don't have to do it right away. And in fact, you can and should take time to both consider the implications of modifying your request or dropping it as the case may be, and also reach out to public institutions or nonprofit bodies that have some resources that could help you with this process. BC Fipa, for example, has lots of information available on its website that can help you make some decisions about whether you want to change the scope of your request. I have seen situations where requesters have been offered previously released information, which seems helpful, and then asked if they wish to abandon their FOI request because of this. And they say yes, only to find that the information that was given to them is not really satisfactory in terms of what they were looking for, but at that point the request is already abandoned. So those decisions can matter, and you want to keep track of the decisions that you make. Again, don't rush it. The next tip I want to say is that an FOI or ATI request will move through the system at the speed of its most complex component elements, which sounds complicated, but it basically means that if you're asking for 4 or 5 different types of records in a single request, you want to think about which one of those types of records might be more complex or difficult to locate and retrieve than others, because this could actually slow the entire request down. Let's say, for example, that you expect that there's probably a couple of briefing notes and maybe a couple financial documents and some media lines about an issue in question, so you file for that. But you also file for all of the correspondence across the entire public institution over a period of 2 years on the same issue. There's a good chance that that correspondence is going to take a long time to retrieve, to process, and that could slow the entire request down. So bearing this in mind, you may want to actually file a separate request for that more complex or time-sensitive element that's going to take a bit longer. Third point, collaborate and ask questions. There's a fantastic right-to-know community in Canada. This is how I learned how to file FOI requests, by talking to people who were experienced, by reaching out for advice. And the community, by definition, is about transparency and open to new members, new people who are interested in getting access to public records. Advice is freely given, in my experience. And so by all means, when you're learning the ropes with FOI, reach out to experienced requesters, reach out to organizations like Fipa, and seek advice. And finally, if there is a delay or an extension with the requests that you're dealing with, first off, consider whether your rights have been violated or were seen to be violated, and consider filing a request for review or complaint about that process. But also, remember to request an interim release of records that have already been processed. If it's going to take 4 or 5 months to pull together everything and get it ready to release to you, and something's already been processed within 1 month, you should have that information in front of you as soon as possible. Again, access delayed is access denied. So I hope that you found this useful. I hope that this is an effective starting point for your own journey as an FOI requester. And of course, this is only the tip of the iceberg, the basics. This is FOI 101. There is more to learn. There's more troubleshooting. And you can certainly rely on the BC Freedom of Information and Privacy Association for assistance as you go through the FOI process. Thanks very much, and I hope you have a good one. The BC Freedom of Information and Privacy Association is an organization whose mission is to improve and defend privacy and transparency as vital components of a free and democratic society. We envision public agencies who are transparent in action and decision, people in control of their privacy and personal information, and privacy and transparency embedded in law and policy. We're one of Canada's few advocacy groups dedicated to access to information and transparency and privacy issues. We conduct research into the public opinion, policy and law that intersect access to information and privacy frameworks in BC and across Canada. And this includes monitoring the performance of public bodies, governments, and regulators in the sector. FIPA commissions studies and provides material that empower lawyers, journalists, students, and the public. In turn, we are frequently consulted on policy issues by politicians and government officials. FIPA's work encompasses legal research, public legal education, public assistance and aid, and law reform that focuses on transparency and privacy issues. If you're interested in these issues and you'd like to learn more, or if you'd like to contribute to FIPA as a donor or become a member of the BC Freedom of Information and Privacy Association, I encourage you to visit our website at fipa.bc.ca. You'll also find us on Facebook, Twitter, LinkedIn, and YouTube. Thanks very much.